Hi, I'm Paul Groh, Director of the Estates Administration Team at the Law Offices of Daniel Hunt. At some point in the trust administration process, you'll reach a point as a trustee when you'll be ready to distribute the trust assets to the beneficiaries. Generally, at that point, you will have inventoried all of the trust assets, liquidated assets as appropriate, dealt with any debt or creditors, and prepared an accounting of all your actions as trustee. So what comes next? Before distributing assets, you'll want to do the following 3 tasks. First, determine how the trust assets will be distributed. Most trusts specify a simple outright distribution to beneficiaries, without any restrictions. If the trust specifies a staggered or discretionary distribution scheme, consult with your trust attorney for guidance on handling those trigger term scenarios. For the sake of this video, we'll be focusing on a simple outright distribution scheme. Second, prepare an accounting and send a copy to the beneficiaries, or have your trust law firm do so on your behalf. The accounting shows the beneficiaries exactly how you arrived at the amount that they are receiving. Third, decide who will be making the trust distributions, you or your trust attorney. Communicate the information to your trust attorney. Another issue to resolve is what kind of distributions will be made. You will want to consult with the beneficiaries to figure this out. 2 main kinds of distribution are in-kind distribution and cash. In-kind distribution includes any titled assets that the beneficiaries have chosen to take as part of their inheritance, such as an automobile, a piece of real estate, stock, or investment accounts. Cash distribution includes funds from all assets that have been liquidated. You can make this distribution using cash, a cashier's check, a wire transfer, or a check written from the trust account. Now let's go over a few do's and don'ts to keep in mind when distributing trust assets. Do. Check in with your trust attorney before you start distributing assets. Ask each beneficiary how they would prefer to receive their distribution, such as whether they would prefer a check versus a wire transfer. Request, but don't require, the beneficiaries to sign a receipt and release document when they receive their inheritance. This document acknowledges that the beneficiary has received and accepted the property distributed. It also releases you as the trustee from future liability after a certain amount of time has passed. Consider keeping a small reserve account of trust funds for handling the final tax return and tying up any loose ends in the trust administration process. Don'ts. Don't try to force a beneficiary to sign a receipt and release in exchange for giving them their inheritance. This is against the law. Don't make distributions that are not authorized by the trust document. This includes increasing or decreasing the amount of distribution as stated in the trust. All trustees have a duty to administer the trust instrument as written and not in any other manner. If you have any questions about how to proceed with distributing assets from the trust estate, please give our firm a call. We hope this video has been helpful, and if you have any questions about estate administration, feel free to contact the law offices of Daniel Hunt using the information listed below. Thanks.